I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel.
Court does call the case of the people, state of Michigan versus Cyrus.
In this courtroom, things are already off the rails before we even touch the actual evidence. We've got a prosecutor saying she's been publicly accused of lying, a defense attorney who apparently put some very personal language into a court filing, and a judge who is about to step in hard on professional conduct. All of this comes out of a case here in Michigan involving serious sexual conduct allegations, where emotions are high, careers are on the line, and the law is colliding with ego. You're about to see a prosecutor stand up and say, "My integrity is everything," while pointing the finger at defense counsel for crossing the line. From legal argument into personal attack. On the other side, you'll hear a defense attorney insist, "This isn't personal, this is professional." Even as the judge flat out tells him, "I expected better from you." And underneath all this drama sits a very technical fight about something called the Rape Shield Statute, and whether certain sexual history evidence is even allowed to be discussed at a preliminary examination. So as you're watching, ask yourself, is this really about the law? Or is this about pride, tone, and respect inside a very small, very public professional world? Stay locked in because it escalates quickly.
Good afternoon, Your Honor. Marieh, Assistant Prosecuting Attorney.
And good afternoon, Your Honor. With also on behalf of Cyrus Abadi standing to me, right? Cyrus, please speak.
Good afternoon, Your Honor. Cyrus Abadi here.
All right, this has come back to me. I don't know if it's really a motion, but I don't know who would like to start, but I certainly have some questions.
I have a few things to put on the record, and I'll defer to Mr. Dowse if he wants to go first. I have no problem with that.
I do not need to go first. So.
Well, you might need to. I'm going to let you put on what you need to put on the record, because I think the last communication I saw, Mr. Dowse had filed something and you had requested whether or not we needed a written response or whether or not you could give an oral response. I think my staff had indicated what my answer was and that you could give an oral response on the record. So if that's where you'd like to start, go ahead.
That's correct, Your Honor, and thank you for the opportunity to do so. I actually don't know where to start. This is a unique situation. I've never been accused in a public filing of lying. I've never been told that my narrative is sanctionable. So I'm not sure exactly where to start. I will start.
Well, I've got some things to say.
What you're hearing, here's a prosecutor drawing a very clear line in the sand. In the legal world, your reputation is your currency. Judges remember how you argue. Other lawyers talk about how you behave. When she says, "No case is worth me losing everything I've worked so hard for," that's not drama. That's the reality of practicing law. She's not just upset that someone disagreed with her. She's upset that, in a public filing, defense counsel used words like lying and sanctionable narrative. That is a very big deal. Accusing another attorney of lying or misconduct in writing is like lighting a flare for the court. It forces the judge to look at it. It invites sanctions, ethics questions, and long-term damage. So let me ask you this. If you were in her shoes and a colleague put "you lied" into a public court document about you, would you be able to let it go, or would you be standing exactly where she is, fighting to defend your name on the record?
About that, but go ahead, because and Mr. Dawes, I'm just going to tell you, I don't expect attorneys to necessarily like each other. I don't even care whether they like each other. Whether they talk to each other is irrelevant to me unless they cannot communicate in some professional way. But as I've told other attorneys, and particularly, and I'll name him Mr. Bennett, when he came and he accused somebody of some type of misconduct, that when that statement is made, the court has to look at that. And so I made it very clear to him, and I'll make it clear to you. If those are the kinds of things that are going to happen, you better be ready to roll with it, and you better have it. Because if you don't, that's sanction. Ms. Tanha, you may proceed.
Your Honor, as counsel knows, and I think everyone in this room is aware, within this profession, our reputation and our integrity is everything. Throughout my career, I've routinely made decisions that were difficult decisions to make in a lot of aspects. I've been able to make those decisions because my reputation and my integrity are that important to me. Quite frankly, no case is worth me losing everything I've worked so hard for. What I've also routinely done in front of Your Honor, as well as other judges, is stand up here and make a point of defending opposing counsels when other people have accused them of anything from lying to misconduct and so on. The reason I make a point of doing that, even though in many situations that has truly not been necessary, is because I want to be very clear how important it is that we don't throw out baseless accusations at people. It's not a new situation to me necessarily to encounter a situation with opposing counsel where we disagree, where we misunderstand each other.
Now this is where the curtain gets pulled back. Most of the time, the public never sees the emails, the side conversations, the snarky remarks between lawyers. But here, she reads one line out loud. You can articulate and posture all you want. Just don't think for a second, I'm not seeing right through you. Is that the worst thing anyone has ever written? No. But in a professional legal context, with serious allegations on the line, that kind of language stops sounding professional and starts sounding personal very fast. She then puts a spotlight on something many female attorneys talk about quietly, being spoken to differently than male colleagues. She's not just saying he was rude, she's saying he would not have talked to a male prosecutor like that. That's a heavy accusation, because now we're not only in the territory of professional conduct, we're in the territory of bias and respect. So here's a question for you. Do you think this email is just normal frustration between opposing lawyers, or do you see it as crossing a line, especially in light of the gender dynamic she's describing?
I don't take offense. I've gone head to head with some of the best attorneys in this county as well as other counties. And not once have I been accused of what defense counsel is accusing me of. And what bothers me more is I actually started out respecting defense counsel a great deal. As far as I knew, we had a fine working relationship, and I had no reason to believe that anything changed. I think I in this situation, have been more patient, respectful, and understanding of this defense counsel than I would have been with a lot of other counsel for that reason, because we started out respecting each other. Obviously, we've hit a point where that's changed. I'm not sure exactly why, and maybe counsel will enlighten us today, but he seems to have a personal problem. I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. Those personal attacks are not just in the written form in these public filings where I'm being accused of all kinds of things.
This is a very smart move procedurally. She is not begging for an apology. She's not asking for sanctions on the spot. She's doing something much cleaner, asking the court to allow defense counsel to withdraw paragraph 5 and have it struck from the public record. Why does that matter? Because court filings live forever. They're public. They follow you from judge to judge, case to case. If a filing says the prosecutor lied, that sentence is going to be read again and again, often without the full context. By asking to strike that paragraph, She's trying to remove what she sees as an unfounded personal attack from a permanent searchable trail. And notice the subtle shot she takes at his ability to represent his client. She suggests his hurt feelings might be interfering with his professional judgment. That's a very polite way of saying he's making this about me instead of about his client. If you were the defendant watching this, would that make you nervous about your own attorney's focus?
They've also been verbal. They've also been contained in an email communication. I haven't done, and quite frankly, Your Honor, I wasn't going to bring this up because I don't take personal offense. This field makes us develop very thick skin. And I don't anticipate in dealing with other people within this field for them to have thinner skin than I do. And perhaps that is my mistake, and I need to be more cautious and aware of people's hurt feelings and how it affects how they conduct themselves. I do want to put this on the record because I think it speaks to why we saw the reply that we saw. This is an email from September 25th of this year from Mr. Douse to myself. It's in response to a request he made, a reply I sent him, which again, we can certainly look at that, but this is the part I'm concerned about. Curious, you can articulate and posture all you want, Marie. Just don't think for a second that I'm not seeing right through you. I don't know what the intent of that email was. What I do know, it's not necessary for what was being discussed. What I know is that it's a personal attack. So I'll just leave it at that. I'll leave it at that. It's not lost on me that unfortunately we live in a society where people who are privileged in certain ways, and specifically being male, think that they can address female attorneys a certain way that differs from how they would address male attorneys. I do this job not expecting to be treated any differently than my male colleagues.
In judge language, I expected better from you is brutal. The judge has just told defense counsel on the record that his filing was below the standard. The court has come to expect from him and his office. That is not just about this one case. That's about his professional brand over decades. Remember, this judge says he's been reading briefs for over 30 years and sitting as a judge for over a quarter century. When someone with that level of experience says, "I was taken aback," he's sending a message to every lawyer in that room. Tone matters. You can argue aggressively. You can challenge the law. But when you start sounding personal, petty, or disrespectful, you risk losing credibility with the one person who actually rules on your motions. So let me put this to you. If you were defense counsel, is this the hill you'd want to die on? Is that one spicy paragraph worth the judge publicly questioning your judgment?
I advocate just as strongly as my male colleagues do. Anything less than that would be ineffective. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel. And even though I probably shouldn't be shocked at this point, having done this job as long as I have, I truly am. Because in working with many different male, female counsels of all backgrounds, this is the first time it's risen to this level. And that's saying something. What's even more concerning to me is that it was done in a public filing. Now, I realize, and I've come to understand that defense counsel's feelings were hurt by what he seems to believe is attitude for me or my treatment of him. I have not treated him any differently than I would treat any other counsel. I've conducted myself in a professional manner when I could. There are times where we have very intense discussions, and that's not out of any kind of intent to offend.
Underneath all the emotion, there is a real legal question here. The defense attorney is basically saying this at a preliminary examination. In a criminal sexual conduct case, I'm allowed to ask certain questions under the rules of evidence without first filing a motion and an offer of proof. He believes the prosecutor was wrong for telling another judge that he couldn't, and he put that objection into writing. On the other side, the judge and prosecutor are treating the rape shield statute like a wall that stands at every stage, including the preliminary examination. In simple terms, rape shield laws generally block most questions about a victim's past sexual history because once that information comes out, you cannot unhear it. That's why the judge uses that cow has left the barn type of logic later. So this clash is not just personality, it's also about where that wall starts, at trial only or from the very first hearing where the victim might have to testify. Quick question for you. Should a victim get full protection from day one, or should the defense have more freedom early on to test the case?
Anyone. I'm quite shocked that defense counsel is as offended as he is by me and the job I've been doing. I was also shocked to read what he wrote. My hope is, because I try to get...
Are you talking about what, and I don't mean to interrupt you, but you're talking about what he wrote in his response?
In the reply. Specifically in paragraph 5. My hope is that counsel's kind of passions and hurt feelings took over and that logic and common sense just didn't catch up quick enough before he filed that reply. So with the court's permission, I'd like to offer him an opportunity to essentially withdraw paragraph 5 of his reply and ask the court to strike.
Here the judge does something very important. He references long-standing practice. He's basically saying, look, in this county for years, we have treated the rape shield protections as applying at the preliminary exam. Your own office has argued it that way before me. That puts defense counsel in a tough spot. It's one thing to make a bold, creative legal argument that the law should be interpreted differently. It's another to act as if the other side is making something up out of thin air when the entire local practice and even your own colleague's history show otherwise. Judges do not like it when lawyers pretend there is zero support for a position that has been followed for years. So from the judge's perspective, this is not just a legal disagreement. It feels like defense counsel is trying to reframe a well-established practice, as if the prosecutor is misleading the court. That's why the temperature in the room is so high. Do you think the judge is being fair here, or is he protecting the status quo too aggressively?
It from the public record. I think that's the appropriate thing to do. I'm not going to sit here and ask for an apology, but at the very least, that is what he could do to remedy the situation. And I do have serious concerns about his ability to efficiently represent his client when he seems to have such hurt feelings and such a personal problem with. So that might be something he might want to consider. And I'm not going to discuss the case. That's something I appreciate the opportunity to put that on the record. I felt the need to defend myself. Judge Barr was present for a great deal of our conversation, actually all of our conversation in chambers. And I'll kind of leave it at that.
As to that issue, and I great hesitation in saying
This is a classic judicial be careful what you wish for moment. Defense counsel is arguing that the formal rape shield mechanism does not apply at this stage, so he should be allowed to ask certain questions without a motion and offer of proof. The judge responds by pointing out his own power as gatekeeper. He basically says, fine, if that's your position, then I can just refuse to hear any of it at prelim, and you can go fight about it in circuit court later. Strategically, that is a nightmare for the defense. The preliminary examination is often the first, and sometimes the only chance to lock in testimony, test the strength of the case, and explore weaknesses in the story. If the judge shuts that door completely, the defense loses a valuable opportunity. So, again, this shows why tone matters. When you come at a legal issue, aggressively you might win the argument, but if you irritate the judge enough, you might end up with a ruling that technically follows the law, yet leaves you in a worse practical position than if you had taken a more measured approach.
Saying this, and certainly Mr. Duss, you can respond if you want to that. When I and let me just say this before you respond. I've read over the years a number of your pleadings, both from you and both from those in your office. I'm trying to be careful in the way that I put this. What I read when I received that.
This is one of the most striking moments in the entire hearing. Defense counsel tries to frame it as a simple legal question. If a judge requires a motion, I'd ask, what's the legal basis? That's a perfectly reasonable lawyer question. But the judge responds with brutal honesty. Because I said so, maybe that's A, you wear the robe and you don't. That line tells you everything about the power dynamic in a courtroom. At the end of the day, judges have incredibly broad discretion on procedure, on evidence, on timing. If you think they're wrong, you appeal, but in real time, you still have to play the game on their field under their rules. As a viewer, you might hear that and think, wow, that's arrogant. As a lawyer, you hear it and think, I better be very careful how I push back from here. So I'll put this one to you. Did the judge go too far with that comment? Or is he just saying out loud what every judge quietly knows?
I was surprised. Surprised, and I will say a little bit taken aback. Mainly because, and you know me, I'll just be blunt, I expected better from you. So, and I say that not with any thought as to how.
Let's translate that ruling into everyday language. The judge has just said, the rape shield protections that limit questions about a victim's sexual history apply at the preliminary examination in the same way they would at trial. You don't get to sneak in more at prelim, just because it's earlier in the process. He also adds a key procedural guardrail. That kind of evidence will not be allowed until the court has a chance to see what is being offered and in what form. In practice, that means defense counsel cannot freestyle into sensitive sexual history questions at the exam. He will need to go through a more formal process, so the judge can decide what, if anything, comes in. From a victim protection standpoint, this ruling makes sense. From a defense perspective, it tightens the leash and limits their ability to test the story early. So where do you land on this? Do you prefer maximum protection for the alleged victim, even at the earliest stage, or do you think that the defense should have a wider lane at prelim to probe the case?
I would rule on this issue because that wasn't really what was playing into my mind. Just expected better. Go ahead, Mr. Dobbs.
Thank you. This is not personal, Judge. This is professional.
Which part?
What I have put in writing and submitted to the court.
No, Mr. Doss. And I'll let you go on. But no, this was clearly personal. I have been reading briefs for and preparing briefs, memorandums for over 30 some odd years. I've been reading them as a judge for over a quarter century.
So let's zoom out and wrap this up. In this hearing, we saw three big themes collide: professional conduct, gender and respect in the courtroom, and a technical but important fight over the rape shield law at a preliminary examination. The prosecutor came in focused on one thing: protecting her integrity after being accused, in a public filing of lying and presenting a sanctionable narrative. She pointed to a snide email. She highlighted what she believes is different treatment. Because she's a female attorney, and she asked the court to let defense counsel withdraw a particularly offensive paragraph from his filing. The judge took that seriously. He told defense counsel plainly that he was surprised, taken aback, and that he expected better. Then on the substance, the judge made it crystal clear. In his court, the rape shield protections apply at the preliminary exam just like at trial. No shortcut, no backdoor. Any attempt to get into the alleged victim's sexual history has to be handled carefully and formally. At the same time, the defense attorney stood his ground, saying he was simply advising the court on what he believes the law is. He may have preserved his legal argument for appeal, but there is no question he took a hit with this judge in terms of tone and professional relationship if you found this case. As shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.